is the nature of Indian Constitution? Is it correct to say that Indian Constitution is federal in character with unitary features? Or Constitution of India is neither purely federal nor purely unitary but is combination of both. It is union of composite states of a novel type. It enshrines the principle that in spite of federation, the national interest ought to be paramount. Discuss this statement. Ans. All constitutions are generally divided into two categories, one federal and the other unitary. Under the unitary constitution, the powers of the government are centralized in one government, and that is generally the central government, and the states are subordinate to it. But in a federal constitution there is division of powers between the center and the state, and both are independent as well as coordinate to each other. The American Constitution is universally regarded as an example of federal constitution. It established dual polity or dual form of government. A federal constitution usually has following essential characteristics. One, distribution of powers. A federal constitution defines and demarcates the sphere of the central and state government. Each government has to act within its own sphere and cannot encroach upon the field of others. The basis of such distribution of powers between center and state is that the matters which are of national importance and in which uniform policy is desirable are given to the center, and the matters which are of local importance are given to the states for legislation and control. 2. A written constitution. A federal constitution is necessarily a written constitution. Distribution of powers can be made between the central and state governments only when there is a written constitution. All organs of the government derive their powers from the constitution and have to function within the defined limits. The validity of all legislative enactments is tested according to the provisions of the Constitution. 3. Supremacy of the Constitution. Under a federal system, Constitution is supreme. All organs of the government have to work within the spheres assigned to them by the Constitution, and they cannot encroach upon the jurisdiction of other organs. The judiciary has to interpret the Constitution and has to see that there is no transgression of jurisdiction by different organs of the government in the spheres assigned to others. The disputes between different organs of the government are settled according to the provisions of the Constitution. 4. Effective role of the courts. The courts under a federal constitution have the final authority to interpret the Constitution and maintain the supremacy of the Constitution. They decide the disputes between the central and state governments. Their decisions on intergovernmental disputes are final. Besides, the courts are the savior of fundamental rights of the citizens of the country. 5. Rigidity. A natural corollary of a written constitution is its rigidity. In a rigid constitution, procedure for its amendment is very complicated. This, however, does not mean that constitution would be legally unalterable. It simply means that power to amendment constitution should not remain exclusively with either central or state government. The Constitution of India possesses all the above stated characteristics of a federal constitution. Constitution of India also provides for dual polity, system of governance at central level and state level, and there is division of power at center and state level, and each level of government is supreme in its sphere. Similarly, Indian Constitution is written and supreme, and procedure of its amendment is difficult as per federal character. Constitution established Supreme Court of India to decide dispute between centre and state or states inter se. Other constitutional matters. In state of WBV, Union of India, AIR 1963 SC 1241 Supreme Court has held by majority that it is not truly federal. However, Subha Rao J. in his dissenting view treated Indian constitution basically federal. However, some scholars are of the view that Indian constitution is not federal. In following matters they point out that the Indian constitution contains modifications of federal principles and make it more unitary than federal. A. Appointment of governors. The governors of states are appointed by the President of India. Articles 155 and 156, and answerable to him. There are provisions in Constitution under which the governor is required to send certain state laws for the assent of President. The President has power to veto those state laws, Article 200 to 88A. However, there are not many examples where President has vetoed the state laws. The only example is Kerala Education Bill, Kerala Education Bill AIR 1958 SC 956. B. Parliament's power of legislation in the national interest. Under Article 349, Parliament is empowered to make laws with respect to every matter enumerated in state list, if the Rajya Sabha passes a resolution by 2/3 majority that it is necessary in the national interest. C. Parliament's power to form new states and other boundaries of existing states. Article 3 empowers Parliament to form new states out of the existing states, and to increase or diminish the area of any state, and to alter the boundaries or name of any state. D. Emergency provisions. The Constitution envisages three types of emergencies: emergency arising out of war or external aggression or armed rebellion, Article 352, arising out of failure of constitutional machinery in states, Article 356, and financial emergency, Article 360. When the proclamation of emergency is made under Article 350 to the normal distribution of powers between the centre and states undergoes a vital change. Parliament is empowered to make laws with respect to any matter enumerated in the state list. Under Article 356, if the President is satisfied that the government of a state cannot be carried on in accordance with the provisions of Constitution, he can dismiss the state ministry and dissolve the legislature and assume all the functionaries of the state. It is true that the above-mentioned provisions modify the federal character of the Constitution. During emergency, the Constitution is converted into a unitary Constitution. But when emergency is over, the Constitution functions as a federal Constitution. The framers incorporated these provisions on practical considerations, taking note of the peculiar problems of the country. They adopted the federal principle applicable to other federations and modified it to suit the Indian Constitution so as to serve the need of the country. The Indian Constitution, therefore, constitutes new bold experiment in the area of the federation. The Indian Constitution is neither purely federal nor unitary, but it is a combination of both. This combination of unitary and federal system is the unique feature of the Indian Constitution. The Indian Constitution is mainly federal with unique provisions for safeguarding the unity and integrity of the country.